Good day, everyone. We're now going to discuss the possible questions that may come up in the upcoming bar exams under the subject of criminal law. Again, disclaimer, these are based from our own opinion, our own insights, and it did not come from any other source. Okay, let's begin. An information for murder was filed against Oka and Roel for the alleged killing of Lito. During the trial, Rose testified that he saw Lito being hugged by Oka while Roel was stabbing Lito. The RTC found Oka and Roel guilty of murder, qualified by treachery, and held that both accused acted in concert towards a common criminal goal. The Court of Appeals affirmed the RTC's decision. Was there conspiracy? No, there was no conspiracy because it cannot be proven beyond reasonable doubt that both accused acted in concert towards a common goal. Conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. The essence of conspiracy is the unity of action and purpose. Conspiracy requires the same degree of proof required to establish the crime, proof beyond reasonable doubt. It was not established that Oka was hugging Lito deliberately to enable Roel to stab him, as he had no knowledge of Roel's intention. This is the case of People versus Gimpaya. While in the market, Calio and Junel discussed a plan to kill the victim, Nando. Most of them went to the victim's house. Junel pretended to borrow a lighter from Nando, who, after handing out a lighter, was unknowingly struck on the nape. Then, Junel hacked Nando. After the victim fell on the ground, Calio jumped in and stabbed Nando's chest with a knife. Thereafter, opened the victim's stomach with a knife, took out his organs and fed it to a pig, and then further sliced the victim's body into pieces. Both were charged with the crime of murder qualified by treachery. Calio, however, contends that it was legally impossible for him to kill Nando as the latter was already dead when Calio stabbed him. Is Calio's claim correct? No, Calio is not liable for an impossible crime because there is an apparent conspiracy and community of criminal design. With conspiracy attending, collective liability attaches to the conspirators, Calio and Junel. The defense of impossible crime is not correct. This is from the case of People versus Callao. Ray Ray, the accused, and others were having a dance battle in front of his house. At around 11:30 p.m., B-Boy AZ arrived and was approached by Big Daddy Ed, and the two danced. Sometime after, B-Boy AZ approached the table where Ray Ray was seated and asked who was brave enough while drawing a knife tucked in his waistband. Ray Ray tried to escape by moving backwards. While doing so, he got hold of B-Boy AZ's right hand and was able to twist the same. Ray Ray got hold of the knife and stabbed B-Boy AZ 3 times on the chest. He ran away immediately and surrendered himself to the barangay officials. Ray Ray raises the justifying circumstance of self-defense. Should this be given due course? No, Ray Ray's claim of self-defense should not be given due course because there is no unlawful aggression present. It has been held that mere drawing of a knife by the victim does not constitute unlawful aggression, whether actual or imminent, as the peril sought to be avoided by the accused was both premature and speculative. At that point, there was no actual risk or peril to the life or limb of Ray Ray. This is the case of People versus Raitos. Lola BBQ was awakened by someone calling her. At that time, she was inside her house. Recognizing that it was her grandson Grim, he then asked why. Grim replied from the outside asking for help. Then she opened the door for her grandson. She then saw Paulie D shot Grim with a .38 caliber revolver from behind. Grim was hit at the nape and then fell on the ground, lying with his face down. Polly D then left the place, passing between their houses. Moments later, Polly D returned and shot Grim 3 more times to make sure that the latter was dead. Polly D invoked self-defense. He asserted that Grim, along with another guy, poked a gun at him and that he needed money. Polly D was able to obtain possession of the gun, pulled the trigger and hit Grim. He was charged with murder, qualified by treachery. Was treachery present? No, treachery is not present because there are no other circumstances attendant to the shooting that shows that Polly D carefully and deliberately planned the killing in a manner that would ensure his safety and success. Under Article 14, Paragraph 16 of the Revised Penal Code, there is treachery when the offender commits any of the crimes against persons, employing means and methods or forms in the execution thereof which tend to directly and specially ensure its execution, without risk to himself arising from the defense which the offended party might make. It was not proven that Polly D had deliberately chosen the place, time, and method of killing, or that the meeting between him and Grim was planned. This is based on the case of People versus Duran. On May 14, 2008, B1, B2, and B3 and some other companions were having a drinking spree. While B1 was singing with his face turned towards the television, B3 suddenly took B2's scythe and hacked B1 3 times on the neck, back, and fingers. B1 died. During trial, B3 pleaded insanity as his defense. Dr. Dre testified that he had previously examined B3 in the year 2005 prior to his arrest. Dr. Dre diagnosed B3 then as having auditory hallucinations, depressed mood with appropriate effect, and was able to converse, but he was not oriented to time and place. He had poor memory recall of the incidents and had blank stares. Dr. Drew again examined B3 after his arrest, leading her to conclude that B3 had poor memory recall of the incidents relating to the commission of the crime, and that he did not know what he did at the time. Is B3's defense of insanity tenable? No, the defense of insanity raised by B3 is not tenable because it was not successfully proven. A decision of the Supreme Court stated that in order to prove insanity as a defense, the inquiry into the mental state of the accused should relate to the period before or at the precise moment of doing the act, which is the subject of the inquiry. His mental condition after that crucial period or during the trial is inconsequential for purposes of determining his criminal liability. The court cannot second-guess whether the accused appellant was insane at the time the crime was committed, based on the case of People versus Bacolod. Liberace killed Vivian, 6 years of age. He was charged with murder. The counsel of Liberace argued that he should only be charged with homicide. Decide on the case. Liberace should be charged with murder because of his act of killing Vivian was attended with the qualifying circumstance of treachery. Jurisprudence states that treachery is present in the killing of children who, by reason of their tender years, cannot be expected to put up a defense. Here, Vivian was murdered at the tender age of 6 years old. Treachery attended the commission of the crime. People versus Pentecostes. A was with his common law wife B when C, armed with an unsheathed weapon, came to the dwelling yelling, "I will kill you all." Then C tried to stab A. Meanwhile, B tried to cover A in order not to be hit again, resulting in B being stabbed on her left breast, which caused her death. C was charged with murder, with deliberate intent and evident premeditation for killing B. Is this correct? No, it is not correct to charge C of murder for killing B because there is no evident premeditation present in this case. The Supreme Court ruled that with respect to qualifying circumstance of evident premeditation, it is indispensable to show concrete evidence on how and when the plan to kill was hatched, or how much time had elapsed before it was carried out. Mere lapse of time is not enough. Also, the mere fact that the accused was armed at the beginning of the altercation does not unequivocally establish that he earlier devised a deliberate plot to murder the victim. Here, there is no showing that C planned to kill B. From the case of People versus Agramon. The defendant PJ attacked, assaulted, hit with a baseball bat, and poured gasoline on live-in partners named Al and Eve, thereby causing them third-degree burns which directly caused their instantaneous death and the burning of the victim's house. The prosecutors argue that despite having two dead bodies, PJ should be charged for a single crime and not two separate counts. Rule on the contention of the prosecutor. The prosecutor is correct in claiming that PJ should be charged with a single crime because he committed a complex crime. Under Article 48 of the Revised Penal Code, when a single act constitutes two or more grave or less grave felonies, or when the offense is a necessary means for committing the other, the penalty for the most serious crime shall be imposed. The same to be applied in its maximum period. Here, the single act of burning the house in order to kill the victims constituted the complex crime of murder, which carries only a single penalty, based on the case of People versus Mercado. Maya, who was then 4 months pregnant, was walking near the railroad track when the accused, Cash, suddenly blocked her path and hugged her. Maya started shouting and begged the accused to spare her because she was pregnant. Despite her pleas, Cash warned her not to shout, otherwise he would kill her, and that he only needed her for a few minutes, 3 minutes max, to satisfy his lust. Eventually, Cash was able to have carnal knowledge of her. Maya reported the crime, and Cash was charged with rape. Cash denied the allegations, stating that when Maya was examined by a medico legal, the latter testified that there were no evident injuries on Maya's genitalia at the time of the examination. Is Cash's contention tenable? No. Cash's contention that the medico legal's report stated that there were no evident injuries on the victim's genitalia is not tenable because this does not negate the fact that the accused had carnal knowledge of the woman. Under Article 266A, Paragraph 1A of the Revised Penal Code, the elements of rape are: first, the act is committed by a man; second, the said man had carnal knowledge of a woman; and third, that such act was accomplished through force, threat, or intimidation. The absence of physical injuries or fresh lacerations does not negate rape, as it is not among the essential elements, based on the case of People versus Lechoso. An information was filed by Liz against Q for the crime of rape. Based on Liz's testimony, Q asked Liz to retrieve him bars of soap inside a storeroom. When Liz entered the storeroom, Q trailed behind her. Inside the storeroom, Q suddenly grabbed Liz's breast and unzipped her pants. While Q was moving his fingers in and out of her private part through the opening of her pants' zipper, he took out his penis and massaged the same. Shortly after, Liz lost consciousness. When she woke up, she was seated on the floor with her underwear and pants pulled down to her knees. Q was charged with the crime of rape, but denied having carnal knowledge with Liz. Rule on the case. The court should rule in favor of Q because there is no showing that he is guilty beyond reasonable doubt of the crime of rape by carnal knowledge. As enshrined in the Bill of Rights, the accused has the right to be presumed innocent until the contrary is proved. To overcome the presumption, nothing but proof beyond reasonable doubt must be established by the prosecution. In this case, there is no evidence presented by the prosecution to prove that there is indeed carnal knowledge that occurred. Although it is possible that Q had carnal knowledge of Liz while the latter was unconscious, he cannot be convicted of the crime of rape by carnal knowledge based on a mere possibility. Therefore, the accused should be acquitted of the crime of rape by carnal knowledge, based on the case of People versus Roelda. Private complainant Lexi was born on July 5, 1987. She was a minor when all 3 acts of rape were committed. She was 11 years old when the first rape occurred, sometime in the year 1998. The second rape happened sometime in the year 1999 when she was 12 years old, and the third time was in January 2000 when she was 12 years old and 6 months of age. At the time all 3 acts of rape occurred, she was living in the same house in San Jose with her full-blood sister, her half-siblings, her mother, and Lexi's stepfather, accused appellant Johnny. Johnny was charged with rape. His defense was that the testimony of the complainant was inconsistent and contradictory in terms of the dates mentioned. Ruled on Johnny's defense. Johnny's defense is untenable because the date or time of the commission of the rape is not a material ingredient in the crime of rape. A ruling of the Supreme Court states that where the time of commission is not an essential element of the crime charged, a conviction may be had on proof of the commission of the crime, even if it appears that the crime was not committed at the precise time alleged. What remains paramount is the witness's consistency in relating the principal elements of the crime and the positive and categorical identification of the accused as the perpetrator of the same. Based on the 2017 case of People versus Herola. 4 separate informations for rape under Article 266A, Paragraph 1, in relation to Article 266B, Paragraph 2 of the Revised Penal Code were filed in the RTC against Ryan for 4 counts of rape committed against AJ, his daughter. Upon arraignment, Ryan pleaded not guilty to all charges. Ryan impugns AJ's credibility for her delay in immediately reporting the rape incidents. He further argues that AJ's testimony should be doubted because she failed to offer any resistance or shout for help during any of the alleged rapes. Is Ryan's defense correct? No, Ryan's defense that AJ failed to offer any resistance or shout for help during any of the alleged rapes is not correct because his moral ascendancy was more than enough to silence her. Jurisprudence states that failure to resist and delay in reporting the crime does not negate the rape victim's credibility. Further, considering that Ryan is the father of AJ, his moral ascendancy was certainly more than enough to silence her. Not to mention the normal tendency of rape victims to conceal their humiliation and shame, resulting from the irrevocable violation of their honor. Based on the case of People versus XXX, dated July 2018. Brad Pitt, Regional Director of PDEA Regional Office No. 2, feloniously threatened via phone call his subordinate George with the infliction of a wrong amounting to a crime by uttering the following words during their phone conversation. "Putang ina mo, George, ha? Putang ina mo, papatayin kita." Over office internal matters and conflict, George filed a case against Brad Pitt for grave threats. Brad Pitt was charged with the crime of grave threats. Brad Pitt said that the prosecution failed to prove his guilt because, at most, what was proven by the prosecution was merely the occurrence of the phone conversation between him and George, but not the substance of the said conversation. Rule on Brad Pitt's defense. Brad Pitt's defense is not tenable because the crime of grave threats is consummated as soon as the threats come to the knowledge of the person threatened. The revised penal code states that the elements for the crime of grave threats are that 1. The offender threatened another person with the infliction upon his person of a wrong. 2nd, such wrong amounted to a crime. And 3rd, the threat was not subject to a condition. Here, all the elements for the consummation of a crime of grave threats are present. The felony was consummated as soon as George heard of the threats during their conversation. Based on the case of People versus Azurin. Zenny was initially engaged in the business of buying and selling appliances, furniture, and other products. She would buy from Alson's Trading, owned by Eros. Eventually, she and Eros had an agreement that her store would be used to establish Alson's Trading in her locality in Pulangi, and became its manager. As a branch manager, Zenny had the obligation to receive the stocks, sell and document them, hire and terminate employees, document and deposit collections in the bank, and be accountable for the shortages in the collection. On the other hand, Eros had the obligation to pay the monthly salaries of Zenny and the other employees. Also, Eros had prohibited Zenny from continuing with her previous business. One time, Eros visited Alson's Pulangi and did not find cash there. Becoming suspicious, Eros had the Pulangi branch audited, where it revealed that there was a substantial shortage of cash. On the basis of the audit, Eros filed an estafa case against Zenny. Is Zenny guilty of the crime of estafa through conversion or misappropriation? No, Jenny is not guilty of the crime of estafa through conversion or misappropriation because she did not have juridical possession of the goods delivered to her, as she was a mere employee and not an agent. Jurisprudence dictates that unlike an agent, an employee has no juridical possession over the funds received because he or she has no independent right or title to retain or possess the same against the owner. The foregoing indicates the existence of employer-employee relationship between Eros and Zenny. From the case of Zenaida versus People. Karen is the directress of the Challenger Montessori School. Mitch and Naomi, both 16 years old and students of the said school, sent a text message to a certain Clara while pretending to be Marites, the daughter of Karen. Marites' mother arrived and got angry at Mitch and Naomi and her classmates who sent the messages for allegedly quarreling with her daughter. Karen called Mitch, Naomi, and 6 other students. There in front of the teachers and other students, Karen shouted at them, shouting the words, "Pinakamalandi, pinakamalilibog, pinakamahadera at hindot," followed by, "Nga putang ina kayo." The private complainants reported that incident to the police authorities. An information was filed against Karen for grave oral defamation in relation to RA 7610, alleging that she uttered the defamatory words which debased, degraded, and demeaned the private complainants' intrinsic worth and dignity, and to their grave humiliation, embarrassment, damage, and prejudice. Should the case be given due course? The case should not be given due course because the crime of grave oral defamation in relation to Section 10A of RA 7610 does not exist. A decision of the Supreme Court noted that Section 10A of RA 7610 is clear that it punishes acts of child abuse which are not covered by the revised penal code. Thus, she cannot be convicted of grave oral defamation under the RPC in relation to Section 10 of RA 7610, there being no such crime. Amor is 14 years old. One day she was about to pick up something on the floor in one of the rooms in their house when, without warning, Canor, her stepfather, approached her from the back. When she turned to face him, he grabbed the lower end of her shirt, inserted his hands inside, and touched her breast, while uttered the word, "Pahawak nga." She resisted, but he tried to pull down her shorts, but she held on the sides to prevent him from stripping her. Sometime after, Amor narrated to her mother what happened. Subsequently, an information was filed against Canor for committing lascivious acts against Amor on the ground of act of lasciviousness under Article 336 of the Revised Penal Code, should the case be given due course. No, the case should not be given due course because the crime should be designated as lascivious conduct under Section 5B of RA 7610, not under Article 336 of the Revised Penal Code. In a case decided by the Supreme Court, it states that if the victim is exactly 12 years of age, or more than 12 but below 18 years of age, or is 18 years old or older, but unable to fully take care of herself or himself, or protect herself or himself from abuse, neglect, cruelty, exploitation, or discrimination because of a physical or mental disability or condition, the crime should be designated as lascivious conduct under Section 5B of RA 7610. Based on the case of XXX versus People dated September 2019. Uno, dos, tres, and cuatro applied for jobs as factory workers abroad in the Green Pastures International Staffing Incorporated, a duly licensed recruitment agency registered with the POEA and owned by Rio. Accordingly, they paid the corresponding placement fees. No receipt was issued to them for the payments of the said placement fees. Uno, dos, tres, and cuatro were promised to be deployed after they had signed the forms, underwent physical examination, and attended the pre-departure orientation seminar. However, such a promise of deployment did not materialize. Worse, no reimbursement was made relative to the placement fee that they were paid. Consequently, an information for large-scale illegal recruitment under Section 6M of RA 8042 and 8 informations for estafa through false pretenses were filed against Rios in her capacity as President and General Manager of Green Pastures and several others. May Rios be charged with both illegal recruitment and estafa at the same time? Yes, Rios may be charged with both illegal recruitment and estafa at the same time. Settled is the rule that a person who commits illegal recruitment may be charged and convicted separately of illegal recruitment under Labor Code and estafa under Article 315 of the Revised Penal Code. The offense of illegal recruitment is malum prohibitum, where the criminal intent of the accused is not necessary for conviction, while estafa is mala in se, where the criminal intent of the accused is crucial for conviction. Conviction for offenses under the Labor Code does not bar conviction for offenses punishable by other laws. Conversely, conviction for estafa under Article 315 of the Revised Penal Code does not bar a conviction for illegal recruitment under the Labor Code. Fermentigas filed an application for a business permit. However, Mayor Yorme denied her application. Fermin went to the office of the Director of Public Assistance Bureau of the Ombudsman, where she was referred to Attorney Abogado. Through a transmittal letter, they wrote to Yorme attaching all the necessary documents for the application for business permit in order for the application to be acted upon. However, instead of replying, Yorme referred the matter to her lawyer. If you were to charge Yorme, what offense should it be? Yorme should be charged with violation of RA 3019 because she refused after due demand and without sufficient justification to act within a reasonable time on the application of permit. Existing jurisprudence states that an application for a mayor's permit or license to do business, all the mayor has to do is to approve or disapprove the application. If the deliberate refusal to act or intentional inaction on the application for mayor's permit is motivated by personal conflicts and political considerations, it thus becomes discriminatory and constitutes a violation of the Anti-Graft and Corrupt Practices Act. The Office of the Ombudsman received an anonymous letter complaining about the alleged irregularity in the purchases of the DOH and CR from pharmaceutical companies. After trial on the merits, the Sandigan Bayan found the petitioners guilty of violation of Section 3E of RA 3019 through evident bad faith in purchasing overpriced medicines and for allowing the purchase of overpriced medicine without public bidding. Can the petitioners be held liable for violation of Section 3E of RA 3019 through evident bad faith or manifest partiality? No, the petitioners cannot be held liable for violation of Section 3E of RA 3019 through evident bad faith or manifest partiality. It has been settled that the absence of public bidding in the procurement of goods does not automatically equate to evident bad faith and manifest partiality. To constitute evident bad faith or manifest partiality, it must be proven that the accused acted with malicious motive or fraudulent intent. It is not enough that the accused violated the law, committed mistakes, or was negligent of his duties. There must be a clear showing that the accused was spurred by a corrupt motive or a deliberate intent to do wrong or cause damage. Luna, who works as a driver for Susan, was asked to drive for Sexy. After leaving a bag at the rear passenger seat, Sexy instructed Luna to proceed to a restaurant by himself. She said that a certain Mike will be arriving there to get the bag and that if Mike will have something to leave for Sexy, he will just have to leave it at the back of the car. Luna went to the restaurant, and a man who introduced himself as Mike approached him and asked where Sexy was. As per instruction, Luna told Mike to get the bag and wait for Sexy. However, Mike announced that he is arresting Luna for carrying illegal drugs. Accordingly, an information for violation of Section 11, Article 2 of RA 9165 was filed against Luna. After trial, the RTC found Luna guilty of the crime charged, ruling that since the bag was in the possession of Luna, there arises the presumption that the alleged packs of drug specimens found inside the bag are owned by petitioner Luna, and therefore, the presumption of animus possidendi is established. On appeal, the CA affirmed the RTC's conviction, holding that since Luna was driving the vehicle where the bag was retrieved, he constructively possessed the alleged packs of drug specimen. Is Luna guilty beyond reasonable doubt for violation of Section 11, Article 2 of RA 9165? No, Luna is not guilty beyond reasonable doubt for violation of Section 11, Article 2 of RA 9165. Despite the offense of illegal possession of drugs being malum prohibitum, it is not enough to show that the accused knowingly and intentionally possessed the bag or receptacle that contained the illegal drugs. The prosecution must go beyond and provide evidence that the accused knowingly, freely, consciously, and intentionally possessed the illegal drugs. Here it was Sexy who placed the bag at the back seat of the vehicle. It was also Sexy who instructed Petitioner Luna to immediately proceed to the restaurant and allow a certain Mike to get the said bag. In short, the person who effectively wielded control over the bag was Sexy and not Petitioner Luna.